I have listened to a lot of double standard talk, a lot of red herring, and clear cases of hypocrisy, particularly on the side of our friends in the NPP in the House. All of this business of going to the Supreme Court, of chastising Speaker Okwe and saying that Speaker Okwe got it wrong, and Speaker Okwe has opened a Pandora's box, shouldn't have done that. The question I ask is, where were all these people 4 years ago? They were still members of parliament. They were still active politicians. So that is really the difficulty some of us have with our politics. The politics of convenience is just becoming too much. The politics of opportunism. When it favors you, it's right, it's good. If it doesn't favor you, tomorrow, it is wrong. So there is no consistency. There is no principle. We need to condemn that kind of politics. It does not build our democracy. It does not augur well for us. We must insist that our politicians, all our citizens, must be consistent. I have in my hands here the ruling of Speaker Okwe from the Hansard of 7th November 2020. Reading from column 98 to column 100. The Hansard, the official report of 7th November 2020, the day that Speaker Okwe delivered his ruling. And this is what Speaker Okwe said. With your permission, I'll read. It's not too long a ruling. Declaration of Fomena seat in Parliament as vacant. Honorable members, before our visitors come in, there is a ruling I have made on the petition for the declaration of the Fomena seat in Parliament as vacant. Parliament is in receipt of a petition from the General Secretary of the NPP inviting the Speaker of Parliament to declare the Fomena seat in Parliament vacant. The Member of Parliament, Honorable Andrew Amwako Esiama, who has been written to, has responded accordingly, and copies are attached to the ruling. The NPP invoked Article 97(1)(g), the same provision I quoted a while back, Article 97(1)(g) of the Constitution of the Republic of Ghana 1992, which provides that a member of parliament shall vacate his seat in parliament if he leaves the party of which he was a member at the time of his election to parliament to join another party or seeks to remain in parliament as an independent member. And please take note of the date. This is in November, 7th November 2020. I've heard some people say, oh, shouldn't Speaker Bagbin have waited? You know, there's an election ahead of us. It's a few weeks. You know, Speaker Bagbin delivered his ruling on the 17th of October. This is 7th November, you know, and Speaker Okwe didn't wait. This is much closer to the 2020 election. Speaker Okwe did not wait. And Speaker Okwe explains why, as I read on. So, Speaker Okwe continues. He says that the Constitution of the NPP, which the MP freely subscribes to, provides in Article 391 that a member of the party who stands as an independent candidate against the officially elected member of the party, or who joins or defers his or her support for another political party or for an independent candidate, when the party has sponsored a candidate in a general or by-election, automatically forfeits his or her membership of the party. The moment the MP filed his candidature with the Office of the Electoral Commission to contest the next election as an independent candidate, it shows clearly that he seeks to leave his party. Speaker Okwe continues. This automatically triggers forfeiture. He cannot have the desire to leave, take a step towards it, by filing as an independent candidate and yet claim to be a member of the party. The step taken to contest against his party automatically triggers forfeiture of membership. Having forfeited his membership of the party on which ticket he was elected to parliament, the operative language of the Constitution is that he shall, which is mandatory, vacate his seat in parliament.
Can you read that part again? This automatically.
It said this automatically triggers forfeiture. Automatically triggers forfeiture. He cannot have the desire to leave, take a step towards it by filing as an independent candidate and yet claim to be a member of the party. The step taken to contest against his party automatically triggers forfeiture to membership. It automatically triggers forfeiture of membership. Having forfeited his membership of the party on which ticket he was elected to parliament, the operative language of the Constitution is that he shall, which is mandatory, vacate his seat in parliament. It says mandatory, vacate his seat in parliament. He continues, going by a purposive interpretation of the present law, constructive actions on the part of the MP is important. With all intents and purposes, he is no longer a member of the party. He has pronounced himself publicly as an independent candidate and has filed papers to compete against the party and its official candidates as an independent candidate on 7 December 2020. On that occasion, this current parliament will still be sitting and operating as an official parliament of the Republic of Ghana. We shall not have a situation adopted freely by any sitting MP where he or she will be campaigning openly against the party that he or she still represents in parliament and yet ridiculously stands against the party. No purposive interpretation of law will allow such ridicule to prevail. Furthermore, after 7 December 2020, when Parliament is still in session till 7 January 2021, how does an MP operate both as an elected independent MP and at the same time an MPP MP if he should win the election? This lacuna of a ridiculous situation is not what is anticipated under the 1992 Constitution. In the circumstances, it is determined that the conduct of Honorable Andrew Amwaku Esiama amounts to vacating his seat in Parliament. Accordingly, we bring this to the notice of the Electoral Commission for the necessary action to be taken in accordance with the law. Signed, Speaker of Parliament. Honorable members, we shall now suspend sitting. This is the precedent in Parliament. And to be fair to Speaker Okwe, before him was the Wayo Seni incident. You remember?
Yes.
Where he crossed carpet. And the automatic trigger applied. It's automatic. It doesn't matter when you do it. The Constitution doesn't say, oh, few weeks to an election you are exempted, or a day to an election, 1 hour to elections, or after elections. All of them. Yesterday I heard Speaker Bagbin, and I followed up at the table office. Fortunately, his ruling has not yet been made available to MPs. Probably today it will be made available. But I listened attentively, and he also relied heavily on the principle of automaticity. Automaticity. An automatic trigger. That he has no options or discretions in the matter. It doesn't matter when, which time of the year, of the tenure. It is an automatic trigger. He is mandated under Article 97(1)(g) to declare the seat vacant. Then Speaker Bagbin also extensively addressed this red herring out there about who should petition. Some people are saying, oh, if the petition doesn't come from your party, then you can go ahead and misbehave. Everybody can pretend that you haven't seen it. The Speaker, that's why I can't wait for his very erudite, well-reasoned ruling to be published. He addressed that extensively.
But interestingly, with Professor Kwei's ruling,
yes,
apart from
apart from
the preliminary point.
Yes.
Where he refers to a petition from the party.
Yes.
And even in that case, he says that in the party's petition, the party states that there is an automatic trigger.
Yes, in their own constitution.
Beyond that, he doesn't rely on the petition in all the reasons that he abuses.
He talks about the fact that there is a notice of poll. Speaker Okwe talks about the fact that you have filed. He says that he did his own checks. You have filed with the Electoral Commission. And then he says that under the Constitution, it is mandatory. It is automatic. So, Speaker Okwe, even beyond, and you are right, beyond the political party constitution and the political party petition, says that once you have filed, which is public knowledge, it's here.
In fact,
it is mandatory.
In the party's petition, the party doesn't say that we have sacked him because of this. The party says that what he has done is an affront to this part of our constitution.
Exactly.
And he has automatically forfeited his membership by virtue of that action.
Yeah. Exactly. And Speaker Okwe says that, look, he is looking at the MP's own conduct publicly. If you look at column 099, it says, going by a purposive interpretation of the present law, constructive actions on the part of the MP is important. He says that it's important. He's not only relying on the petition from the party. He says that the constructive actions on the part of the MP is important. With all intents and purposes, he is no longer a member of the party. He has pronounced himself publicly as an independent candidate and has filed papers to compete against the party and its official candidate as an independent candidate on 7 December 2020. This is it. So why all the hypocrisy? Why the double standards?
Well, maybe they believe Speaker Okwe was wrong.
Why did they say it then? Why didn't they go to the Supreme Court then? You see, let's stop this whole, politics of convenience. The Ghanaian people are tired of that. It's cheapened our politics. Let's at least remember positions we take and where we have always stood. This business of, because it favors me today, I'm going to go with it. Look, there are other instances that these are politics of double standards and hypocrisy. It's going to come back to haunt us even more. You remember the Abdullahi case? Where the Supreme Court held that majority in Parliament and the majority to take decisions should be 138. And that the Deputy Speaker can vote and all of that. That was the Supreme Court decision. It was hailed by our friends on the other side because it then allowed them to say that, okay, so the budget for that year, which had been rejected by us, they say we didn't have 138 to reject it. Then, as fate will have it, e-levy, they didn't have the numbers. They were 136. Yet they railroaded. When we walked out, they said, no, we don't care. We have passed e-levy. We went to the Supreme Court. I am still at the Supreme Court 2 years now. Honorable Haruna Idrisu, Honorable Mahama Yariga, and myself. No expedition. The Supreme Court didn't show the urgency it did in the Abdullahi case because they know it's open and shut. The politics of convenience. We have been paying e-levy all these years. A decision 136, below the threshold, below the constitutional threshold. But we are paying e-levy. They are ridiculing our case in court. They say we can go to hell. The Supreme Court is not attaching any agency. Only last night, now I hear them saying, but you know what? Okay, yes, you are the majority now, but you are 136. So, be warned, you can't take decisions under Article 104 of the Constitution. Oh, really? You didn't know this when e-levy was being passed? You didn't know that? So you see how we are mutilating our Constitution, destroying our democracy because of the politics of convenience, naked partisanship. Now suddenly, you know that Article 104 is important. You didn't care about that. when you were passing e-levy, an obnoxious, draconian tax, which the overwhelming majority of Ghanaians were opposed to. Then it didn't occur to you. Then the Supreme Court, we are all watching. E-levy, they were not bothered. No sense of urgency. LGBTQ, 8 months. Stalemate.
Well, yesterday, according to the papers, yesterday the Supreme Court is giving Parliament 7 days to file. So they are being proactive now.
Yes. So only God knows when that proactiveness began. If this matter of the NPP becoming minority in Parliament and they run into the Supreme Court for salvation, and everybody is waiting for what kind of interpretation will be given to Article 97(1)(g). That all these years we haven't been reading 97(1)(g) properly. All the speakers before Professor Okwe himself, Speaker Bagbin, we are all waiting. Suddenly, now they are giving Parliament 7 days. Suddenly, they can act on LGBTQ. Suddenly, the Supreme Court can act expeditiously. So let's watch it. Let's be consistent. Let's be principled. That is at the gravamen of this whole matter. It is important that whatever position we take, let's remember that it can come round. What goes round can come around. It can come back to haunt you. Whatever you sow, that shall you reap. If something is right today, it cannot suddenly be wrong tomorrow.